Welcome to Nasdaq Trade Talks. I'm Jill Malandrino, global markets reporter at Nasdaq. Joining us at the MarketSite studio, we have Craig Seebald and Mike Scarborough. They are antitrust attorneys with Vinson and Elkins. We're here to discuss how companies should be thinking about competition issues and antitrust law. It is great to have you both with us. Craig and Mike, welcome to MarketSite.
Thank you for having us.
And Craig, I want to start with you. Why do litigants file anti-suit trusts, and how come they face such a tough road?
No, that's a great question. Let me just step back for a second. So who can file antitrust suits? You have consumers, you have the government, and you have aggrieved competitors that can file antitrust suits. And so what they usually file these suits is they have a problem with the market. Something's not working, whether there's potential price fixing, whether a company is engaging in monopolistic activity. So our laws are very favorable that allow lots of plaintiffs to be able to sue to make, to try to rectify those kind of situations.
And why is it sometimes a tough road to face?
Yeah, so antitrust suits, it's really been the case that they last a long time. So people think, oh, I'm going to file this antitrust suit and we're going to get the market working right. But they tend to drag on for a number of years. So it's not an instant remedy. It tends to work out fine, but it just takes some time. And the other thing that makes it complicated, it's very fact intensive. We talk a lot about what's the market. And you know, it takes a lot of facts and it takes a lot of consumer information. You have to look at documents, you have to look at emails. And so it just takes some time to figure out what the market is and what the harm is and how that really nets out, whether it really is anti-competitive or not anti-competitive.
And we heard a lot about this over the summer because it extends into sports too, which everyone in our audience can relate to. But with the PGA LIV dispute, 11 pro golfers filing an antitrust suit against the PGA, arguing that they're unfairly controlling their players, and it's very anti-competitive. It really restrains and puts a monopoly on professional golf. Is there a case here, and how do you think both sides are going to argue it?
Yeah, to the point I was just saying earlier, a lot of my friends in the sports world say, gee, you know, it's hard to believe this case is dragging on for so long. And I say, oh my gosh, this is lightning speed. The fact that they're trying to have a trial next year is almost amazing. But yeah, there's an antitrust case here. So you really have two big issues. One is, so the players are saying, look, you consider us to be independent contractors, but the rules of the PGA Tour say that I have to go get the approval of the commissioner before I can play a rival tour. And of course, the commissioner said, I don't want you playing this live tour. You either have to be loyal to the PGA Tour or not. And so I think from the players' perspective, they say, this is anti-competitive because if we're really independent contractors, we should be able to pick and choose which tournaments we play in. And from the PGA Tour's perspective, they're saying, look, if you worry about in a monopolization case, exclusion, right, exclusion from the market. And so if I'm defending the PGA Tour, I'm saying, what exclusion has there been? Liv, you're having tournaments. You have players. You've got some of the best players in the world. You're able to pay them. You're putting tournaments on. You've got sponsors. You're now on TV. How have we excluded? If we're excluding you, we've done a really bad job at it because you're now competing. So how can we now be liable for an antitrust? So there's two sides of the story, and that's why I think we'll probably see a trial next year and let the jury decide what's the right outcome.
What potential antitrust issues could companies face as a result of the FTC's non-compete proposed policy? This is something in financial services that we're very well aware of.
Yeah, you know, and it kind of ties into what I was just saying about the PGA Tour. So just like you could say maybe the PGA Tour's restrictions are non-compete because they're saying you can't go play with Liv. So let me just step back. So the FTC has Section 5 of the FTC Act, which is this statute that says it regulates unfair methods of competition. Very vague. Who knows what that means? It kind of changes with administration. But what they've done under Section 5 is put out this proposed order. It's a proposed rule. It's not in place yet. It's a proposed rule, which is basically banning all non-competes between an employer and employees. And it would just fundamentally change the landscape in this country. I mean, you think about how commonplace non-competes are. And I heard the other day, Mike, that there got 10,000 comments in at the FTC on this proposed rulemaking, which is unbelievable. I mean, you have rulemaking and maybe a few people, law professors, will put in comments, but the fact they've got 10,000, I think, is pretty alarming. So it's a proposed one. They'll take this into account, and maybe they'll come up with something. But you know, the other interesting thing is it doesn't apply just to non-competes in the future. It's also saying basically all non-competes between an employer and employee will be illegal. And so how do companies deal with it? It's going to be a real big difference in the law if it really happens.
It would be a massive pivot for sure. Mike, Craig had mentioned that litigants face a tough road in antitrust cases. Do you think antitrust claims won't stick until it's modernized a bit, antitrust laws?
Well, I think it's important to realize that not all antitrust claims are created equal. There's really a large variety of claims. You know, a Section 1 case, which is about, you know, horizontal competitors doing things together that they shouldn't be. You know, you oftentimes will have a Department of Justice investigation. You might have a guilty plea, which really binds the litigants in civil litigation after that. That case is really not that hard to prove on its fundamentals. You may have complex issues of class certification. You may have, you know, sophisticated damage analyses, but essentially it's how big is the check going to be? Whereas a case like a Section 2 case, which is about monopolization, it's about what a single firm has done. Essentially what you're doing is you're saying this firm that has gotten very, very successful, we don't like something about what you did that got you there, and we're going to tell you that after the fact. Well, that type of case, that should be hard to prove. It is hard to prove, but it should be hard to prove because you're bringing in treble damages. You have potentially in a competitor case joint and several liability. So, you know, I think the system is working as intended, and there's a whole variety of cases. Some are easier to prove, some are harder, but it's working really as intended so far.
And it's interesting because federal regulators are expanding the scope, how they're evaluating antitrust issues, particularly the FTC. They're asking about ESG, they're asking about labor unions, they're asking about privacy issues. I mean, ESG of everything is just so highly subjective. What's happening there?
And so this is something that's happening really in the merger clearance process. If you have a deal that reaches certain thresholds, you have to tell the merger clearance agencies. And what happened a few years ago, really at the FTC, is the attorneys that are handling these things, they started getting questions about, well, how's this deal going to affect the labor unions? How's it going to affect you know, privacy concerns at your company? And everyone's heads just kind of exploded and said, I've never been asked this question. I've been doing this 30 years. I've never been asked this question. And these are new questions. So what they're doing is, you know, the companies, of course, if the FTC asks, you've got to respond. And so you give them the data that they want, and it's dragging out the process to get from the time a deal is notified till the time that it's cleared or that no case is filed. It's dragging out that process. What has not happened so far is that neither the FTC or the DOJ has actually filed a case saying, you know, this deal passes traditional metrics in terms of what's it going to do to prices and market concentration and consumer choice. But I find that this is going to blow up the unions at these companies. And on that basis, I'm going to file a competition challenge to stop this deal. So we haven't seen that yet. It'd be really interesting to see what happens if and when that case is actually ever filed.
And you've both brought up Section 2 of the Sherman Act and the DOJ's revised stance on that. Is it significant?
Well, so the latest thing that's really happened over the past year is that the DOJ has said, we are going to start prosecuting Section 2 cases criminally. That's something they haven't done for 45 years. And so the very first instance, they've actually done that on 2 occasions. The first instance, they had what was really a Section 1 case, a competitor collusion case, where one party offered up an anti-competitive agreement, the other one said no, and they turned them into the feds. And that's really a Section 1 case, but because there was no actual agreement, they had to prosecute it as a Section 2 case. That doesn't really seem to me like a true Section 2 monopolization prosecution, but the DOJ is making noises like they're going to do this. Personally, I don't think this is ever going to come to fruition. Proving a Section 2 case is enormously difficult, even in a civil context. You have to have a very, very detailed market analysis. As Craig mentioned, you really have to get into the weeds. What's the right market? What are the market power dynamics? And to prove all of that beyond a reasonable doubt, it just seems like a bridge too far. I don't think it will ever really happen.
Yeah. And companies, certainly the Fortune 500, they're all global these days. We have DOJ, we have FTC, there's other organizations globally that have their own anti-competitive and antitrust practices. How does that work in something like in a merger? Do all the entities work together, or is it separate within each locale?
Yeah, let me take that. So we're lucky in this country, I guess. We have 2 antitrust agencies. We got the FTC and the Justice Department, and that's really unusual. And they have a kind of a loose alliance to figure out who takes what deals. Like traditionally, The FTC has done a lot of energy deals, so they tend to get the energy deals, and the DOJ gets a lot of healthcare. So it just gets divided by industry. But when you have a big merger, like we're seeing a lot of big mergers, you generally see a lot of coordination between the different foreign agencies and the U.S. agencies. So there is a lot of informal dialogue between the two. The laws tend to be a little different, like the Europeans apply the law a little differently than we do, so not always the outcomes are the same, and maybe a merger affects Europe in just a little bit different way than the United States, so there can be differences, but they think they've done a very good job, especially in the last 30 years, trying to coordinate their activity much better.
Yeah, Mike, certainly for sure when it comes to privacy and data, it's certainly a more tight game in the EU, if you will. More highly restrictive.
Absolutely, and as Craig mentioned, the agencies around the world do look at things a little bit differently. Like right now, our DOJ has said, we're not going to settle cases. If we think there's a problem with a merger, we're actually going to challenge it. We're not going to settle it, require some kind of divestiture, something like that to try and fix the problem. A lot of the, and that's kind of a deviation from the historical norm in the US. A lot of the regulators around the world are much more open to settling. They're saying, okay, how do we fix this? If the problem is you got too much concentration in this one area, okay, we'll get rid of that asset, and now the problem is fixed. So there are interesting differences that develop and they change over time in the global context looking at deals.
Are antitrust laws modern enough? I know it seems like a remedial type question, but companies are so focused on data, on technology. We're going into a whole new realm with AI and machine learning and so forth, and that opens up, talk about patent law in that kind of world, but it just opens up, a whole other can of worms because everything is so digitized these days.
Yeah, I could start. I actually think they are. I mean, the antitrust laws are fairly general, and so it's really up to the courts and juries to apply them. So I think the general principles still work. I think people asked this question 20 years ago too, like with Microsoft, and I think it's worked fairly well. One important thing is, at the end of the day, the Justice Department can bring as many cases as it wants, and the FTC can bring as many cases as it wants, but they have to win in court, and they're not doing a great job winning in court. And I think they need to figure out why they're not winning in court, because I think that's an important thing. So as our viewers think about it, yeah, it sounds scary that the Justice Department and the FTC are bringing a bunch of cases, but their record in court has been pretty dismal in the last couple of years.
Yeah, and Mike, to wrap up here, your thoughts on modernization of antitrust laws?
I mean, the antitrust laws themselves, as Craig said, are very, very basic. So it's this dynamic, evolving creature that, it's largely judges and juries that evolve the law, and they can adapt it into new directions to deal with new technology. So I think they are modern enough, and we just need to keep, the DOJ needs to keep bringing the tough cases, as they say that they're going to do. Okay, we'll go out and win some of these, make the new law, apply it to this new area. AI is a great point. I think we're going to see a lot of interesting new cases on, can two different AIs collude with each other? I don't know, but we're going to litigate this, and we're going to figure it out in court, and the law will evolve. It's always going to lag the technology by a certain amount of time, but we will get there.
Mike, Craig, appreciate the insight. Thanks for joining us on Trade Talks. And thanks for joining me. I'm Jill Malandrino, Global Markets Reporter at Nasdaq.